A tough task now to sum up and to report and get a resolution. Well, for that I would definitely like your cooperation. As I have already touched upon during the last session, the I won't say a majority, but there is a unanimous consensus to the fact that what is needed first and foremost is change of mindset of the people involved, the stakeholders, both the arbitrators and the practitioners. And Manan sir had given us a very, uh, interesting and enlightening views on how we do it, because that's what I was asking you, that how do we change the mindset? And he was gracious enough to help us arrive at some of the solutions to that. First and foremost, what he harped upon or he pressed upon was changing the basic education system. The core education system should be changed and made more specific towards creating pool or creating only exclusive arbitrators and mediators. Secondly, he said that what we need to make the system which is currently adversarial, as we all know, India, I think you will all agree that India is one of the most litigious countries. We do so much of litigation, and that's why we have so many cases pending in the court. And therefore, that needs to be changed. Our mindset towards that, towards litigation, towards disputes, needs to be changed. And how we do it, we do at the very, first level of education, law schools, universities. Then he also made a suggestion on the legislative framework for assessment and accreditation, which is also very important. Another suggestion which was made was making the system open for all, not restricting it only to lawyers or legal people. We need pool of arbitrators, pool of trained, qualified and experienced arbitrators and mediators or dispute resolution practitioners, I would say. And therefore, we should not be restricting this system only to lawyers. All those who are qualified, who are experienced enough to adjudicate a dispute in the particular field should be encouraged and be part of it and should be given due weightage and recognition. Having said that, I would now like you all to add to this what I've just said, so that that can be recommended to the committee already been constituted, and we can have a resolution sent across with all the suggestions. Please. Now it is all open. Yes? See, what I was asking is to have the suggestion and so what we were just, what I just made one point on that, and in fact, Mr. Manan sir actually made that, is that there has to be a legislative framework for assessment and accreditation. I think that covers what you were saying.
We had the same issues with the mediators, accredited mediators. Where there is an organization at the higher level of the country. So most of them were We also streamlined it to either judicial officers who get trained in mediation or the lawyers with minimum 15 years. So there's some kind of a guideline as to who can. In addition, the rest of the training and the further training, specialized training, etc. At least when they do that, when there is a misconduct at the instance of a mediator, we can at least bring it under the other misconduct under the Bar Council rules and the Amendment Advocates Act. Now, would this apply to a person who is an arbitrator, who is actually doing an adjudicatory work, in the sense judiciously, disposing certain thing or resolving a dispute? And in the course, if something bad goes, where is the control level that we have? Now, I'm happy if everything goes perfectly fine, but when you substitute something which is really good with another, without adequate, regulatory, regulatory provisions or the, institutions, there can be a worse, mistrust in the whole system, which is very damaging for all of us who come in as arbitrators.
I think that was which I actually missed it, because Mr. Menon sir also mentioned about this, of having a bar or regulatory body, a licensing authority for both arbitrators and mediators, who would take care of the doubt what you just raised. Oh, just a moment. Let me just clear the doubt. So I hope, sir, this is what you were just asking about?
Mediators for a major class we already have. We have the MCPC controlling it, which practically handles probably 90% of the mediations in India. At least it could be quota next, but then still there is an organization which certainly gives a fear that, if you misconduct, you're going to be in trouble. The people
So that's,
who have been removed also on that account.
So
but
if
arbitrators have not found one, that's the reason.
So if there is a authority who, authorizes an arbitrator to practice as an arbitrator and also, take care of any misconduct and all.
On a different level. If it's a lawyer, today, practically a majority of them are lawyers. When a lawyer, in his capacity as an arbitrator also, misconducts, he possibly can come under something else.
That's what I'm saying.
Yeah, but
here we are talking of
other people,
no,
non-lawyers, non-advocates. Probably that level of control will also be lost. Not that I'm against engineers coming in. I always feel that engineers should be here. They are what the lawyers don't know. They certainly know much better. Specialists in particular field. But there is always an alternative that somebody who has got that legal background. Additionally, you could have somebody else. You can even take. There are provisions whereby you can take the assistance of a technical expert. The way it stands today, I'm saying my whole talk is on the basis of the way the law stands today. Tomorrow, if you have a regulatory authority, I have no objection bringing in anybody else as an arbitrator. That's all. Until we provide that kind of a check measure, it may be a little dangerous.
But sir, even today, law doesn't prescribe any qualification to be an arbitrator.
That's a
Correct. So therefore, when you are saying that if a lawyer is an arbitrator and he does some misconduct, there is a proper authority where you can go and approach. Whereas for the non-lawyers, that's exactly the suggestion what Menon sir was making, that when you are an arbitrator, you are not a lawyer or a non-lawyer. You are an arbitrator. You have to forget your profession. You are there as an arbitrator. So there is no differentiation between a lawyer arbitrator or a non-lawyer arbitrator, correct? And that's why we want to have what was suggested, that let there be a separate regulatory authority. Whether the person is a lawyer as an arbitrator or a non-lawyer arbitrator, it doesn't matter. You would be there under that separate authority as an arbitrator. Correct? Yeah.
Some of the states are having some provisions related to this, and as far as not obeying the arbitration
Okay. Suggestion was already made, and in fact, I was just discussing with Honorable Justice on the current situation of, problems of enforcing an award or implementation award, not award, an order, especially under Section 17. So I was giving an example of an NBFC or a simple car hire purchase agreements, where day in, day out, the NBFCs are facing this problem. They are unable to take possession of the vehicle because the police does not give sanctity to the order passed by the arbitrator. They will always ask that we want a court order. So now this mindset needs to be changed. So where we have to address now those authorities who are actually responsible for execution or implementation of the arbitrator's award or order, they need to be trained, made aware of the situation, now sanctity of the arbitration proceedings. Coming to the second part, the third party funding, what you just mentioned, can you just tell how that is going to benefit the system as such?
Okay, sir. Now, I think we will appropriately word the resolutions, taking note of all what has transpired here, and finalize it.